Thulani Mngomezulu, who was recently appointed as defense lawyer for accused number 1 Muzi Sibiya, contended on behalf of his client and accused number 2 Bongani Ntanzi, who was represented by Sibiya, that the duo's arrests were wrongful and unlawful, while the Defence Counsel challenged the processes used for the apprehension on the 30th of May 2020 and the 16th of June 2020, respectively. Well, here is what Mngomezulu told the court.
The rights of accused number 1 and number 2 were violated. As I've indicated in terms of the arrest was unlawful in respect of accused number 1. Number 2, there was no warrant of arrest when he was arrested for a murder case of Kwanongom. Up to now, the state has closed its case. Accused number 2 has never been taken to Kwanongom. It's my submission that he was unlawfully arrested and kept in custody. That violated his right to freedom.
So both accused maintain they never confessed to alleged involvement in Senzo Meyiwa's murder, nor did accused number 1 Muzi Sibiya point out any place.
The defense is going to respectfully submit that from the evidence given by accused number 1, that he was assaulted, that he was tortured, that he was choked, it's the evidence that the court at the end of the day will make a ruling in terms of whether there was such an inducement. Accused number 1 says, yes, after I was assaulted, I had no choice. I had to protect my life because there was no one who could assist me. He had no option but to sign a statement. Then the defense will later then address legal issues in terms of the admissibility of such processes of proceedings of recording a confession. It's evidence also by accused number 1 that pointing out of the 5th of June 2020, it did not point out any place. He disputes that he directed the driver to a place where the alleged offense, or a particular place in Phosphorus. The evidence of Ntanzi should be accepted as both reasonably and possibly true. Even accused number 1, he gave a very consistent evidence.
While the defense then says the state has failed to prove its case.
The state must prove beyond reasonable doubt that a particular confession in terms of section 217 or a pointings out in terms of section 218 or an admission in terms of section 219 capital letter A must have been made freely and voluntarily in sound and sober senses without being influenced thereto. It's my submission that the state has dismally failed to prove those elements, those requirements. In the state's failure to prove those elements dismally, the state did not satisfy this court that the rights of both accused in terms of Section 35 of the Constitution were properly explained.
Sipura Musipile, who represents accused number 2 Bongani Ntanzi, will begin closing arguments on Monday. Criselda Lewis, SABC News at the High Court in Pretoria.